All right. Welcome, kids. We're back for another fun-filled episode of Laughing at Delete Lawz and his lawsuit. So I've I've been a little slow. I think that's the word for it, slow. But the filing, the speed of the filing has also been slow. So after there was a sort of a flurry before Christmas, and then it just went quiet for a week or two, where there were a few filings, but they were short, and I was waiting for something more substantial. So the next flurry looks like it started. So a recap. Um, so right before Christmas, looking at the docket sheet. So on the 23rd, Benjamin Wish, Kate's attorney, filed a motion to dismiss the first amended and supplemental complaints filed by Delete Lawz. Josh Garrick for Josh Abrams filed the same. And if you remember, when I covered them, they were self-referential, so I liked that. And then on the 24th, Delete Lawz filed another emergency motion for contempt of court because Kate made another mean video about him, which, broken record. It's ridiculous. It's not contempt. Today we're going to cover. So after Christmas, Kate filed her motion to dismiss, or sorry. Kate filed the opposition to Delete Lawz motion to dismiss her counterclaim, which is real short and sweet. I like it, as you'll see once I open it. And then we had a full week of silence before, on January 4th, Google returned its waiver of service. So Google is now officially served and on the clock. Then on the 6th, Delete Lawz filed his first memorandum. It's almost as if he knows he's going to be doing more garbage, because how many memorandums does he need? But first memorandum in opposition to number 95, the motion to dismiss, basically the motion to dismiss filed by Josh. I guess we can expect the same in response to Kate's motion to dismiss in a couple days. And then today, the docket is still lacking detail. It says leave to file document. He wants to file another supplemental complaint against Kate. So yeah, that's going to be fun. But with that, let's jump into the filings. So first, we have Kate's filing the opposition to plaintiff's motion to dismiss Kate Peters' counterclaim. Now, if you remember, Josh filed his motion, basically his opposition to the motion to dismiss his counterclaims, a few days before Kate filed this. And it was 7 pages long. It was a very well-written motion. you may notice this one is a grand total of 3 pages. The last page is certificate of service. We see the top of page 1, the top half is the caption. The bottom half of page 2 is the signatures. So this is a grand total of 1 page, which I like. If the motions to dismiss were self-referential, where Josh Garrick referred to Benjamin Wish's his writing and vice versa, this is even more so. So, opposition to the motion to dismiss. Defendant and plaintiff in counterclaim, Kate Peter, Ms. Peter, hereby opposes plaintiff and defendant in counterclaims, Jose Maria de Castro, Mr. de Castro, motion to dismiss Ms. Peter's counterclaims in its entirety. Mr. de Castro has lobbed every idea he can think of for dismissing the counterclaims, of which he can conceive, but none has any basis in the law. Mr. de Castro's motion should be denied. Ms. Peters' sole claim for defamation survives. So this is what we want. This is the analysis. Mr. de Castro moved to dismiss the counterclaims of defendant and plaintiff in counterclaim Joshua Abrams, Mr. Abrams, for exactly the same reasons as he has moved to dismiss the counterclaims of Ms. Peter. In opposition to the motion to dismiss of Mr. de Castro, Ms. Peter thus incorporates by reference the arguments of Mr. Abrams located in ECF number 93. Ms. Peters' counterclaims set out factual allegations supporting a claim for defamation. Indeed, Mr. de Castro's lies about Ms. Peter, broadcast to his nearly 50,000 subscribers, most of them probably purchased, on YouTube, amount to per se defamation. Mr. de Castro has falsely proclaimed that Ms. Peter sold out her daughter for sex, and went so far as to crassly lie that Ms. Peter pimped out her own kid, and the Division of Family Services took her children away, ECF number 54. He has further misrepresented that Ms. Peter was arrested this year for siphoning gas out of a car. These false accusations of crimes are patent defamation. Worse, Mr. de Castro's lies about Ms. Peter's daughter take aim at the most sensitive and important aspect of Ms. Peter's life, her children. There is no basis for dismissing Ms. Peter's counterclaims. The court should deny Mr. de Castro's motion in its entirety. So, as we've discussed, delete Lawz, one of his big motivations in filing this case and in filing repetitive motions is to drain Kate of attorney's fees. And, well, that's not going to work for much longer, since Kate has said once the money's gone, she's going pro se. So that's going to be a problem for delete Lawz on a couple of fronts, because number one, it takes away his stated goal of bleeding her in legal fees. But number two, as we've seen in multiple filings where delete Lawz has whined, I am pro se, therefore the court has to go easy on me. You have to take things in my best interest. But all of a sudden, once Kate's pro se as well, the court will have to take her pleadings in the most favorable light as well. So, haha. But yeah, so I like this, though, because it's like, hey, judge, take a look at docket number 93 filed by Mr. Abrams. We concur. That's our legal analysis. Read that, apply the facts alleged here, the pimping Kate's daughter and siphoning gas, and bing bang boom, that's our motion. Short and sweet. I like it. So next, we have the first filing from Google, YouTube. So I probably should have pulled this up earlier. Let's see. So federal rules of C, our old friend. We've been here many times before. So here's to spin the internet wheel. Rule 4, I believe, is what we want. And once again, wait for it to load. So, waiving service for subsection D, waiving service. Requesting waiver. An individual, corporation, or association that is subject to service under Rule 4E, F, or H has a duty to avoid unnecessary expenses of serving the summons. The plaintiff may notify such a defendant that an action has been commenced and request that the defendant waive service of a summons. The notice and request must be in writing and be addressed to the individual defendant or, for a defendant subject to a service under Rule 4H, to an officer or managing or general agent or any other authorized agent, basically. Name the court where the complaint was filed, be accompanied by a copy of the complaint, 2 copies of the waiver form appended to the Rule 4, and a prepaid means of returning the form. Inform the defendant using the form appended to Rule 4 of the consequences of waiving and not waiving service. State the date when the request is sent. Give the defendant a reasonable time of at least 30 days after the request was sent, or at least 60 days if sent to the defendant outside of any judicial district of the United States to return the waiver. So basically, 30 days if you serve someone in the United States, 60 days if you serve someone outside the United States, and send it by first-class mail or other reliable means. Failure to waive, if a defendant located within the United States fails without good cause to sign and return a waiver requested by a plaintiff located within the United States, the court must impose on the defendant the expenses later incurred in making service and the reasonable expenses, including attorney's fees, of any motion required to collect those service expenses. So, time to answer after a waiver. So this alters the standard time to waive or to answer. If you recall, after being served, not through waiver, but after being served by a process server, you have 21 days to file a responsive pleading. Kate and Josh received an extension because they said, "Hey, look, we're looking for lawyers. Please give us more time." And the judge granted more time. But here, a defendant who, before being served with process, timely returns a waiver need not serve an answer to the complaint until 60 days after the request was sent, or until 90 days after it was sent to the defendant outside any judicial district in the United States. So basically, 60 days after the waiver was sent, they have 30 days to agree to waiver. So 30 days after the receipt of the waiver. So let's look back. The waiver of service was received on, well, Delete Lawz sent it on December 3rd. Well, this is clearly a typo. Either way, it was docketed on January 4th. The answer is due. Okay, it says text modified on the 4th. So received on the 3rd, answer due on February 1st of 2023, which is going to seem weird to say for a while. So unfortunately, we probably won't see YouTube's answer, although I'm guessing they're not going to file an answer right off the bat. I'm guessing we get a 12b6 motion to dismiss because this is a lawsuit. But I'm guessing we don't get that at the very least until January 31st, if not February 1st. But let's go back to the rules. If you remember, it mentioned the appended notice at the end of the rules. And if you look here, Rule 4, notice of a lawsuit and request to waive service of summons. So in parentheses, it says caption. So that's where you'd put the caption of your lawsuit. So here, Jose Maria de Castro versus Joshua Abrams, Catherine Peter, and YouTube, Google. And then this is literally what he would have sent to YouTube. Why are you getting this? A lawsuit has been filed against you or the entity you represent in this court under the number shown above. A copy of the complaint is attached. This is not a summons or an official notice from the court. It is a request that, to avoid expenses, you waive formal service of a summons by signing and returning the enclosed waiver. To avoid these expenses, you must return the signed waiver within, give 30 days or 60 days, depending, from the date shown below, which is the date this notice was sent. 2 copies of the waiver form are enclosed, along with a stamped self-addressed envelope or other prepaid means for returning 1 copy. You may keep the other copy. What happens next? If you return the signed waiver, I will file it with the court. The action will then proceed as if you had been served on the date the waiver is filed, but no summons will be served on you, and you will have 60 days from the date this notice is sent to answer the complaint, or 90 days if you're outside the U.S. If you do not return the signed waiver within the time indicated, I will arrange to have the summons and complaint served on you, and I will ask the court to require you or the entity you represent to pay the expenses of making service. Please read the enclosed statement about the duty to avoid unnecessary expenses. I certify that this request is being sent to you on the date below, signed, and then we have the waiver of the service of summons, which is shorter, but I'm not going to read it from here because we have this one that was filed. Waiver of the service of summons. And like I said, you'll see the caption, to Jose de Castro. I have received your request to waive service of summons in this action, along with a copy of the complaint, 2 copies of this waiver form, and a prepaid means of returning 1 signed copy of the form to you. I, or the entity I represent, agree to save the expense of serving a summons and complaint in this case. I understand that I, or the entity I represent, will keep all defenses or objections to the lawsuit, the court's jurisdiction, and the venue of the action, but that I waive any objections to the absence of a summons or of service. I also understand that I, or the entity I represent, must file and serve an answer or a motion under Rule 12 within 60 days from December 3rd, 2022, the date when this request was sent. If I fail to do so, a default judgment will be entered against me or the entity I represent. Dated December 15th, 2022, from Google LLC. And if we thought that Kate and Josh were paying high legal fees, you know, I'm guessing that Benjamin Wish, as a partner at a fairly small, let's be honest, fairly small for Boston law firm, but with his experience and his, I'm guessing he's billing at $800 an hour. And Josh Carrick, having previously worked at the same firm as Mr. Wish, I'm guessing is billing about the same. But this is signed by Benjamin D. Margot of Wilson, Sonsini, Goodrich, and Rosati in New York City. This lawyer, well, I don't know if he's a partner. I don't know if he's an associate of counsel, whatever. He very well could be billing $1,300, $1,400, $1,500 an hour. Wilson Sonsini is one of the biggest, most prestigious, high-powered law firms in the world. I mean, Delete Lawz thinks this is the Delete Lawz show. He's going to get an education here. It's even if he's just on the hook paying Google's 12b6 motion to dismiss, he could be on the hook for $10,000 easy to Google alone. So that's going to be fun. But next, filed on the 6th of January, we have plaintiff's response to opposition to defendant's motion to dismiss. That is a lot. Plaintiff's response in opposition to defendant's motions to dismiss per Rule 12b. For starters, I don't know that a response was needed. Kate and Josh definitely won't need to file a response to this, sort of a SIR response or whatever you'd call it. But this is just asinine. Okay, no. I'm getting ahead of myself. That's the problem with claims and counterclaims and back and forth. And this is Kate and Josh filed their motions to dismiss Delete Lawz claims. This is the response to that motion to dismiss. So yes, this one did need to be filed. for some reason, my brain went to this is delete Lawz filed his motions to dismiss their counterclaims. They filed their opposition to his motions to dismiss, and then this was nuh-uh. So that's to the honorable judge of said court. That's not needed. As I've mentioned before, you can tell there are at least 3 different people writing motions for delete Lawz. I don't think, from glancing at this one, I don't think this one's him. Comes now, Plaintiff Jose Maria de Castro, an individual appearing pro se in the above titled cause, hereby file this, his response in opposition to defendant's motion to dismiss under Rule 12b, and would show the court as follows. 1. Case activity. Okay. Plaintiff filed his original complaint, ECF number 1, on the 2nd of September 2022, which was amended on the 16th of November 2022, ECF number 62, in which he seeks restitution for damages and other relief for injury he has suffered by actions of these defendants, including, in part, defamation and copyright infringement. No. You dropped your defamation claim. There is no defamation claim on the table. You amended your complaint. The amended complaint has no mention of defamation. Of course, in their motions to dismiss, Kate and Josh did say, hey, by the way, even though it's not on the table, we still want it dismissed with prejudice. We want finality. Each of the defendants filed motions to dismiss plaintiff's action, ECF numbers 94, 95, and 96, to which plaintiff hereby files his response in opposition. Argument and memorandum. Plaintiff's complaint complies with Rule 8. No, it doesn't. If you recall, Rule 8 of the Federal Rules of Civil Procedure are the pleading standards. You've got to make a short and plain statement of jurisdiction, the parties, the sufficient facts that, if taken as true, could form the basis for a cause of action, and you've got to state the cause of action and your prayer for relief. Well, he hasn't stated sufficient facts. We don't know which videos he thinks are infringed or which videos are infringing. That alone means it's not pled with adequate sufficiency, sufficient detail, I should say, to satisfy the Iqbal and Twombly standards for Rule 8. So, to state a claim for copyright infringement, plaintiffs may only allege that seems to be a limiting statement. It's, I'm only able to allege this. It's not, I can only allege up to this point. It's, you've got to allege at least, but may only allege, 1, that they own valid copyrights. I mean, he does. They're not registered, so he is filing. He's suing prematurely. So that they own valid copyrights and that defendants violated one or more of the exclusive rights set forth in 17 U.S.C. Section 106. For example, by copying or distributing plaintiff's copyrighted works. See Feist Publications, Inc. versus Rural Telephone Service Company from the Supreme Court in 1991. The problem is, like I said, he hasn't said which videos are infringing on which of his videos. He hasn't registered his copyright. We simply don't know. We can't guess. If you're guessing, that means he hasn't pled sufficient facts. Moreover, Rule 8A requires, in pertinent part, that plaintiff's complaint include a short and plain statement of the grounds upon which the court's jurisdiction depends, the jurisdictional statement, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for judgment for relief the pleader seeks. Yeah, that is the standard. That is Rule 8A. But like I said, you have to have enough facts in there that the judge can see that there's a claim. Those facts have to be, like I said, I made this video on June 1st. On June 5th, the defendants infringed that specific video in this specific video that they made on their channel. And I registered my copyright. I agree. He does own the copyright to his videos, but he hasn't registered it, which is a required step before you can sue for copyright infringement. That is the law. And you have to have the registration before you even commence action. He doesn't. He can't show that. And that's even before you even discuss fair use. So he fails on Rule 8. He has not stated a cause of action. He has not stated a claim upon which relief can be granted. And there was another thing I was going to say, but I forgot. Oh well. Defendants suggest that the complaint fails to plead specific works and ownership. Exactly. And fails to properly allege infringement. The face of the complaint shows that those arguments are without merit. No. Okay, what I was going to say. Remember Josh's motion to dismiss. Mr. Garrick included parts of the YouTube terms of service, which grants license for other YouTube creators within fair use to use their video. He granted a license by uploading it onto YouTube. That is also dispositive. But he says, so defendants suggest that the complaint fails to plead specific works and ownership and fails to properly allege infringement. The face of the complaint shows that those arguments are without merit, except it doesn't, because we still don't know which videos he thinks infringe or are infringed. First, only one of the defendants even questions my ownership in their motions for dismissal under 12B. I mean, he owns them. He owns his videos, but we don't know which ones he thinks were infringed. He hasn't said. Defendants in their prior motions admit to and list specific recording that infringe on plaintiff's existing copyrights. Defendants in their previous motions admit to and list specific recordings that infringe on plaintiff's existing copyrights. No. Where? I mean, I skip over it half the time in Josh and Kate's motions, but this should be cited. ECF number 90 at paragraph 2. Instead, we're guessing. But they don't admit to infringement. They don't. Additionally, potential confusion as to which recordings of the defendants are infringing can be further clarified through the discovery process. No. Discovery isn't where you make your allegations. You have to bring a complaint upon which relief can be granted. The complaint isn't a fishing expedition. You have to say, this is what they did. This is why I deserve relief. I mean, and then dismissing the plaintiff's complaint would seem premature at this stage of litigation. No. It's not premature. That's why the 12B motions to dismiss exist, some of which are waived if you don't bring them at the start. Some, like jurisdiction, are never waived. You can bring them at appeal if for some reason the court has lost jurisdiction or whatever. But that's precisely why it's there. It's, well, yeah, I haven't pled sufficient facts, but, it would be premature to kick out my insufficient case just because it's insufficient at the time that it's supposed to be kicked out for being insufficient. Then why would they have the rule? That's asinine. At this stage, plaintiff need only allege ownership of the copyrighted recordings, which he has done. You need to allege ownership of the specific recordings. You have to specify which ones you own that were infringed. You have to specify which of their videos infringed. You haven't done that. But you also have to show you registered that copyright, which you have not done. There is no case. Any question as to plaintiff's ability to prove the well-pled allegations of the complaint is not relevant in the context of a Rule 12b-6 motion. So, any question as to plaintiff's ability to prove the well-pled, that's the problem. It's not a well-pled allegation. It's lacking. It's not, there's not sufficient facts. It's not there. I mean, yeah, the plaintiff does not have to prove the allegations in the complaint for a 12b6 motion. In fact, those allegations are treated as if they're true for the purposes of the 12b6 motion. And if everything taken as true could support that cause of action, the case gets to continue. But if you say, I'm taking all of these pled allegations as if they're true, but even if all of this is true, I can't make a cause of action out of it, it's got to be dismissed on that 12b6 motion. I mean, that is what he doesn't understand here. He's arguing, I don't have to prove it. No one's saying he has to prove it. No one. They're saying he hasn't provided us anything. I mean, he continues, any contention that plaintiffs should be required to prove allegations of ownership at this juncture is simply without basis. That's because no one's alleging that. No one's contending that. I mean, such an obligation would put an increased burden on the court clerks without benefiting the defendants. Okay. I'm not seeing where the court clerks come in. That's a good non sequitur. But once again, you look, like, go back a couple videos. Look at his motions to dismiss the counterclaims. I mean, they were a delete Lawz special, all conclusory statements. No analysis, no facts, just conclusory statements. Which this is as well, but I mean, he's misstating what the motions to dismiss even said, because no one's saying he has to prove anything. We know the standard for a 12b6 motion. We know that the allegations are taken as true for the 12b6 motion. No one's arguing that, except for him. But you have to have enough there. He needs to remember, go look at Iqbal and Twombly, which we've discussed multiple times. You can't create a claim that's not there. Okay. Glancing at the next section, this might drive me to drinking. This is asinine. The fact that the defendants have not requested a more definite statement, but rather asks that this court decide fair use, makes it clear that the complaint was sufficient to give notice. The fair use determination is not obviously in the favor of the defendants and is obviously against them. The defendants are in the same market and have admitted it in their videos and have infringed on works of plaintiff that are unpublished, where courts have found that fair use is not a defense, regardless of purpose. Once again, those are conclusory statements that fair use is obviously against them and not in their favor. But the first part of that paragraph is the worst. The fact that the defendants have not requested a more definite statement, why the hell would they? It's your job to give a definite statement. It's your job to state your claim for relief. If you do not state a claim for relief, it is their job to say, hey, judge, get rid of this. There is no claim here. It's not, well, you're not quite there yet, but could you try again? This is further proof. He is the stupidest person on the planet. I guess paragraph 9 in its entirety would be his conclusion for that. Plaintiff's complaint complies with Rule 8. Yeah. And you'll notice there is no, well, I guess there is an apostrophe to make plaintiffs possessive. I mean, but then was this like his stand-in header that got kicked to the end? Because there's no period there. It's just a open-ended, incomplete sentence, but plaintiffs capitalized, complaint capitalized, complies is capitalized, with is uncapitalized, rule capitalized, and then the numeral 8. Yeah, it doesn't. But RICO. What's that saying again? It's never RICO. RICO is the lupus of the legal world. Except in rare cases, such as Young Thug or whatever it is going on in Atlanta right now, it's never RICO. But this is even more asinine. He says, as to RICO, RICO is only used as a jurisdiction method for defendant Abrams to be in the same action, but is pled sufficiently in the mass copyright infringement for financial gain occurring by the defendants. That's his entire argument about RICO. Where do I start? Number one, his argument in the amended complaint, where he alleged RICO, was RICO. It's RICO because in a RICO case, if venue is good for one defendant, it's good for all defendants. Abrams and Peter are both residents of Massachusetts. You don't need RICO. You don't need RICO to get Josh in. He's in Massachusetts. But it's only being used as a jurisdiction method. Well, then it's not RICO. Unless there is a RICO cause of action, it is not RICO. It's not RICO. Should I say it again? It is not RICO. Es ist nicht RICO. My German is very bad. I'm not going to try any other language. YouTube and YouTube terms of service. Defendant Abrams raises defenses related to YouTube terms of service. wow, he actually can cite ECF number 96. That, I mean, he's actually citing, it's improperly cited. It's not part of that sentence, so you wouldn't put Defendant Abrams raises defenses related to YouTube terms of service, comma, ECF number 96. You do YouTube terms of service, period, and then ECF number 96. That's the citation is a separate sentence. Abrams has no way to know which agreements that plaintiff has entered into with YouTube. Except he does, because if it's the standard terms of service, you agreed to it when you signed up. And if it's the current terms of service, you received a checkbox at some point saying, hey, we've updated our terms of service. Do you agree? And in order to continue, and since you have a channel, we know you did, you click, yes, I agree. Now, I mean, unless you're able to show a different terms of service that you've agreed to, saying, well, even though this is the YouTube terms of service, Abrams doesn't know what I agreed to. Well, then show us what you did agree to. Saying Abrams doesn't know, you're not refuting anything. You're not bringing anything to the table. But the small portion of a specific version of a generic YouTube term of service that Abrams allegedly pulled from YouTube's website does not apply here. Nor has Abrams interpreted the passage correctly, nor is it even possible to interpret the passage with the entirety of the document, as it's not cited in a way to know what the remainder of the document might have been. They cited it. Look up the YouTube terms of service. It's there. You can find the YouTube terms of service. Control F, do a search. You can find that section. If it's not there, say it's not there. But for some reason, Josh's well-pled motion to dismiss that cites the YouTube terms of service doesn't put Delete Lawz on notice of what Josh is pleading. But Josh has to guess which of Delete Lawz videos he infringed in which of the accountability for all videos. Consistency is definitely not Delete Lawz' strong suit. Certainly, all visitors to the YouTube website do not give up all of their creative content into the public domain. This is irrelevant to a 12B motion to dismiss for failure to state a claim. Who said they gave up all? And it's not public domain. You have granted a license for use on YouTube under certain conditions. And all YouTube creators have agreed to that. The extent to which it applies could be a question, but it definitely is relevant, though, to a 12B motion, because let's say it's not fair use. Let's say a completely different hypothetical. I buy a house. I sign a contract to buy a house, and the My brain's just not working to come up with hypotheticals. But either way, the existence of a license. Okay, let's say I'm speeding, and I'm pulled over and I'm given a ticket for speeding. I hand my driver's license to the cop, and my driver's license is valid. I realize this is criminal, not civil, but it's the same principle. He gives me a ticket for speeding and a ticket for driving without a license. First thing I do, I show up to court and I say, look here, judge, he gave me a ticket for driving without a license. This is my valid license, which I had at the time of the ticket. You've got to dismiss. Well, we can't figure that out now. That's an issue for trial. We can't figure it out at the equivalent of a 12B motion to dismiss. We've got to keep going. No, if the license is there, that means there's no claim. There's no valid claim if there's a license, and the license is agreed to through the YouTube terms of service. It's asinine. Conclusion. The plaintiff's complaint pleads a plausible case that allows the court to draw the reasonable inference that the defendants are liable for the misconduct alleged. The plausibility is to the claim as a whole and not to each individual allegation, and the courts have determined that each fair use determination requires a trial of the facts. The plausibility is to the claim as a whole and not to each individual allegation. First off, citation needed. Without a citation, that is a delete Lawz specialty, a conclusory statement. And it's simply not true. A court can dismiss some claims and not others. And that's one of the reasons he needs to plead with sufficient clarity and specificity so that we know. He needs to say, this video infringed on this video because, and then this video infringed on this other video because. The court might find, hey, yeah, there's no facts that for this first claim that could meet it. It's gone. But the second one, maybe there's some question of fact. Let's keep it in. And at this stage, it's not determining fair use requires a trial of facts. It doesn't if you haven't pled. You need adequate Rule 8, Iqbal and Twombly. You need to plead sufficient facts to even get the copyright claim to survive, even before the affirmative defense of fair use is taken into consideration. It's just not there. Plaintiff requests the court to deny the defendant's motions for dismissal of its claims and or grant it leave to amend the complaint where it believes the complaint fails in the interest of justice and to prevent further expense by all parties. Dated the 6th day of January, 2023. I mean, the nonsense he's pulled over and over and over and over. Why does he think he deserves leave to amend? And the interest of justice, that's one of the reasons the 12b-6 and other 12b, 1 through 5, is there at the start. Sometimes the interest of justice requires it to be kicked out early, before the defendant exhausts a $50,000 retainer. Don't you think that's in the interest of justice? So, once again, that was just a whole lot of conclusory statements with no actual legal analysis, not a single citation in there. It didn't look like the standard Jose de Castro methed out word salad, vomited onto a page. But it was still his level of analysis. It was better written, but as far as a legal motion goes, it was the same old nonsense. It's just complete garbage. So finally, we have from the 11th of January, which I'm still saying is today, even though as I'm recording this, it's currently 1:57 a.m. on the 12th, but I'm nocturnal, so my day blends. Motion for leave to file second supplement to first amended complaint. Yeah, this is going to be good. At least this one's short. I guess if he's granted leave to amend, it's not going to be this short. But motion for leave to file second supplement to first amended complaint. Pursuant to Federal Rule of Civil Procedure 15D, Plaintiff Jose de Castro, plaintiff or I, respectfully moves this honorable court for leave to file plaintiff's second supplemental complaint to add defendant Catherine Peters' latest copyright infringement of a previously unpublished video as mentioned in ECF number 97. That, I'm guessing, is the video Kate did where Delete Lawz was arrested in 2015, I think, where he didn't know how to hammer a flyer onto a tree. Real alpha move there. Not that I believe in alphas and betas and sigmas, whatever, but if there were alphas, they'd know how to hammer. It's the video being unpublished by him doesn't automatically make it a copyright infringement. And I don't know that it is unpublished. He provided it to an anti-police brutality organization. What is it? Or no, was it PNAC? I think photography is not a crime. PNAC, I think, if I remember right. And he provided it to them thinking it made him look good. And they basically laughed at him. I don't know if they published it or not, but he gave it to them probably in the understanding that they would publish it. Unless he said, you have license to publish this, but only you have license to publish this, he might have a problem there because, you know, he gave it to them to publish and they gave it to Kate to publish. He probably granted a license. And unless it was a restrictive license, he's going to have a hard time. But his argument, courts may permit supplemental pleadings, setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. Federal Rule of Civil Procedure 15D. The First Circuit has recognized that courts customarily have treated requests to supplement under Rule 15D liberally. U.S. ex rel. Gadbois v. Far America Corp. from 2015. This liberality is reminiscent of the way in which courts have treated requests to amend under Rule 15A's leave freely given standard. See also Keith versus Volpe from the Ninth Circuit in 1988. So that's not binding law in the First Circuit. Rule 15D is intended to give district courts broad discretion in allowing supplemental pleadings as a tool of judicial economy and convenience, and its use is therefore favored. Here, plaintiff filed his first amended complaint on November 16, 2022, document 62 on the docket, after which Peter infringed on another of plaintiff's copyrighted videos as mentioned in ECF 97. Plaintiff could not have known that Peter would have behaved in this tortious manner until after his first amended complaint. That is another conclusory statement. Peter infringed on another of plaintiff's videos. Yeah, I don't think she did infringe. I mean, and if he amends and actually states I'm not saying it would be a valid cause of action. I'm saying if he pleads sufficient facts in a supplemental complaint as to this, it would be the very first time. No factors exist that would support denial of plaintiff's motion. See for America at 7. Listing some factors a court may consider in denying a motion to supplement. Plaintiffs have not unreasonably delayed attempting to supplement. This motion comes less than 30 days after the facts arose, with 2 holidays during that time. The supplemental pleading will not unduly prejudice the defendant and will help prevent her having to participate in another related suit. And Peter decided to make further infringements during this action. Plaintiff's supplemental claim is not futile. Plaintiffs have pleaded allegations which, if taken as true, as they must be at this stage, state a claim for which the court can grant relief. See Hatch versus Department for Children, Youth, and Their Families, First Circuit, 2001. An amendment is not deemed futile as long as the proposed amended complaint sets forth a general scenario which, if proven, would entitle the plaintiff to relief against the defendant on some cognizable theory. Once again, he says the supplemental claim is not futile. Plaintiffs have pleaded allegations which, if taken as true, as they must be at this stage, no one's arguing that. For a motion to dismiss or summary judgment, It's got to be taken as true. But once again, they do not state a claim for which the court can grant relief because you have not stated a claim for which the court can grant relief. It's not there. Taking everything you've said as if it's true still does not satisfy anything the court can grant relief for. It's not there. At some point, you'd think he might finally understand this, but he's not going to. He's incapable. But he concludes, since supplementation will aid in the speedy and effective relief of plaintiff's related claims, I respectfully request the court grant plaintiff's motion for leave to file a second supplemental complaint. So there are pending motions to dismiss from both sides at the moment. As of the previous motion I read right before this, they are now both opposed motions to dismiss. Granting leave to supplement based on this newest video, it saves him from having to serve her for this alleged infringement, but it has no bearing on the merits of any other claim. So even if he's granted leave to supplement, the court can still chuck out all the other claims. It can get rid of Josh. It can get rid of YouTube. It can get rid of all the defamation claims. It can get rid of the unknown previous copyright claims. If anything, it keeps him definitely within the jurisdiction of the court for the counterclaims against him. I don't think those go away automatically because he consented to the jurisdiction of the court by filing there. I think those survive, both Josh and Kate's. So, but supplementing and keeping a claim against Kate, which he's going to lose as well, it's clearly fair use. He seems to think, well, it's unpublished, therefore, but the problem is not like we've discussed the factors in fair use before. I'm not going to look them up again and go over them. And yes, it being unpublished weighs in his favor, but there's 4 factors and not any of them are dispositive on their own. Fair use is a continuum. You've got to look at all the factors, and she satisfies most of them. And at least 2 of them are heavily in her favor. So you take 2 factors heavily in her favor, 1 moderately in his favor, and 1 sort of down the middle, the money, because Kate makes money on it, but that's only 1 factor. She's also not taking any money out of his pocket because people aren't paying her to watch his video. They're paying to watch her reaction and analysis of his video. So she's not taking money from him. So that one, even if you put that right down the middle, too heavily in her favor, one down the middle, one moderately in his favor, she still wins. Most likely. Once again, look at the Akilah Hughes versus Sargon of Akkad case. I think Hughes versus Benjamin. In that case, it was found to be fair use. The offending video, well, non-offending video, I should say, did not, there was nothing added. There was no commentary added, no analysis, no captions that I know of. It was entirely her video edited down. That was fair use. So it, you could say one factor was in his favor, in Sargon of Akkad's favor. I'm assuming he made money on it. I don't know. But you put one of the four in his favor, and it was still fair use. That's a bad fact for delete Lawz. But with that, it's now 2:11 in the morning, and I've got cotton mouth, and it's like I've said before, this is the hottest room in the house. So I'm going to leave you here. Thanks for joining me. Do all the YouTube like, subscribe, share, bribe your friends to do the same. Hopefully after my short, too long holiday break, first week of it was just holiday busyness. Second week was me being busy and lazy, but hopefully I'll be more regular once again. I've added fiber to my YouTube diet. So I'll see you guys again soon. Thanks for hanging out. Have a good day. See ya.